30% of people over the age of 65 don't have a will. So on today's program, we're talking a little bit about some of the things that you need to be thinking about to make sure that you have in fact checked the box, so to speak, on that one. Before the break, we were talking about a couple of different things. Number one, it's easier than ever before to do a will, especially with technology today. You can go online and do one at your leisure. You don't even have to leave the house. And a lot of them will have 800 numbers that you can call and talk to a lawyer. Caveat, of course, on that one that we mentioned in the last segment is that if you have a more intricate situation, then I would suggest that you absolutely go see a professional. Go see a lawyer if your situation is a little bit more unique. Certainly important to go see a professional when you've got a situation that requires that. And then the second thing that we were on, that we talked a little bit about before we went to break, was that a will is only part of the equation. There's actually two additional documents that you need besides a will, and that is a healthcare surrogate, and that is a power of attorney. So a healthcare surrogate basically gives somebody the ability to make decisions of a medical nature along the way. So that's kind of important, particularly if you're needing some medical attention or going in and getting a surgery or operation, things like that. Also, power of attorney is important as well, because that gives a person the ability to make decisions as it relates to sort of business affairs. So you got the healthcare surrogate, you're giving somebody the ability to make decisions relating to health, hence the name healthcare surrogate. And then the other document, power of attorney, it gives that person the ability to kind of make all of those other types of decisions. So both of them are important. You also want to maybe throw a living will into the mix, if you will, in terms of the important documents. But fine to have a will, that's a good first step, but make sure you get the healthcare surrogate, power of attorney. If you want to throw a third one in there, it's a living will as well. So welcome to today's program, Dollars and Cents, where we help you make sense out of all of life's decisions involving your money. Hard to believe that it is Thanksgiving coming up. My goodness, right around the corner. We happen to be Central Florida's longest running radio show, coming to you here every Sunday morning at 9 on both the News Radio Orlando network, along with 96.9 The Game, Monday night game for the Bucks, if you're paying attention to what's going on in the NFL. Also, one of the top 25 financial planning podcasts on the World Wide Web, with over 13,000, I think. We're over 13,000 now, downloads of our program. My name's Joel Garris of Nelson Financial Planning, where I'm a certified financial planner, certified financial fiduciary. At Nelson Financial Planning, our team of certified financial fiduciaries stands ready this week to help you change your life with a successful and cost-effective financial plan that provides you superior investment results and peace of mind for the future. So next up on this list of things to be thinking about if you're in that category, which is shockingly large, of folks that don't have a will, is, and this one's maybe hard, and is this something that you put on the table for Thanksgiving? I don't know. The point would be is that you don't want to avoid the hard conversation. So maybe you don't have those at Thanksgiving. Maybe you wait until maybe the day after. But nobody gets out of here alive, and what's going to happen and where things go and who they go to, don't leave that to interpretation or chance, or worse, what the state says, because if you die without a will, then your assets are going to get distributed based upon state law. So don't avoid the hard conversations. We know they're hard. The reality is that it's important to have them so you can make sure that things go according to what you would want. And speaking of that, speaking of state law, every state is different. So just be aware that if you don't have a will, some states say, okay, fine, it all goes to the spouse, okay, regardless. Other states will say it goes some to the spouse, some to the kids. So recognize that there's differences among the different states. Again, that's why it's important to have a will, so you don't have to go down that path of having the state basically set out your game plan for how your assets are going to be distributed. So Of course, next up would be you can do one at any time, right? We talked about doing it at 10 o'clock at night on your laptop, just using one of the online functions. You can do one anywhere, anytime. A hospital room would be not exactly the ideal location, but it can be done. Understand the difference between somebody that is sick versus somebody that is incompetent. If you're incompetent, meaning you're not able to make decisions, maybe you're gone into stages of Alzheimer's or what have you, you're not going to be able to have the capacity to sign a legal document. But if you're sick, cancer or something awful like that, then you can certainly do a document if you're sick. There's a difference between being sick versus incompetent or incapacitated. So, and then along those same lines of having this the hard conversation, think it through in terms of the decision maker. I think oftentimes we see people having the oldest child be sort of the default decision maker in terms of the executor, or maybe they're the power of attorney or what have you. The problem is that name may not be the best fit. Maybe they live in a different location. Maybe they don't really manage their finances particularly well. The reality is that don't just pigeonhole and say, okay, I'm going to just have my oldest be the one to be the decision maker. The reality is don't be afraid to sort of shift things up or even divide things up or have shared responsibilities or consider the geographic location. So a few more items to be thinking about in terms of a will. We'll roll through them real quick. If you're married, each of you must have one. The notion of joint wills, that's a terrible idea. Some states don't even recognize them. The other part, sort of this is an offshoot of having the hard conversation. You either treat everybody the same or be prepared to have the hard conversation now, because that lingering after death, and we've seen that happen more than once in our 20 years of helping clients navigate through these difficult decisions. If you wait and you're gone, then it's left to interpretation as to why things were not equal. So have those hard conversations. And the reality is it's not one and done, right? If you create a will, it's important to go back, regularly review it. Life events will change things. You may move to a different state. Some people may die, those kinds of things. So it's not just I did it and I'm done. It's important to kind of go back and review it as well going forward. So anyway, while we're on the kind of topic of death, not to kind of put a black cloud over the show to talk this much about death, but these are certainly important things to be thinking about, whether it's wills or whether it's debt. And one of the things that people sort of forget is that debt can also be pretty damaging, and most folks don't realize what happens to their debt when they die. And there's an old expression, death and taxes, you're not going to be able to avoid them. The reality is, depending on the type of liability, you might very well have that continue on after you are passing. So that's going to stay with the beneficiary. So make sure you sort of understand, which things are going to stay with the particular asset or investment and which things are in fact unsecured and ultimately won't be an issue, but they'll still be an issue on your estate, because that's where credit cards and things like that would come into play to try and get some money from your estate. So I think it breaks down into making sure that you look at who's responsible for the debt, if you will. So if somebody co-signs it, or somebody's a joint account holder, or if it's your spouse, or someone co-guaranteed it, or it's your personal representative going through the estate process, understand that all of those people may have some level of responsibility to be able to pay those debts. And in some states, spouses are required to deal with the debt of a spouse on any joint property. A co-signer alone obviously is going to be immediately responsible for that, and even an executor can be personally responsible as well. So what types of debt do you want to, or liability do you really want to be most concerned about? Well, first and foremost, hey, death and taxes, it's taxes. Income taxes estate taxes, things like that, the IRS is going to chase it and can chase it throughout the rest of your time, or your beneficiary's time, if you will, going forward. So we're going to take a break. We get back from the break, we're going to finish up this conversation in terms of what types of debt can in fact be inherited and be the responsibility of your beneficiaries. Coming up next here on Dollars and Cents with Joel Garris.